Before we begin, it's crucial to understand that the information in this presentation is for educational purposes only and does not constitute legal advice. The divorce process is complex and laws vary significantly by state. You should always consult with a qualified attorney in your jurisdiction for advice regarding your individual situation. The single biggest mistake people make in a divorce has nothing to do with who gets the house, the car, or even custody of the kids. The biggest, most expensive, and most emotionally draining mistake is not understanding the process. It's like trying to navigate a minefield in the dark. You take a step, hope for the best, and are completely shocked when things explode. That explosion can cost you tens of thousands of dollars, months, or even years of your life, and the emotional well-being of you and your family. If you're watching this, you're likely standing at the edge of that minefield, feeling overwhelmed, confused, and probably a little bit terrified. You've heard the horror stories from friends. You've seen the dramatic courtroom battles in movies. And right now, the path forward looks like a tangled, impossible mess of paperwork, legal terms, and emotional turmoil. This video is your map. This is your night vision. Over the next 10 parts, we are going to walk you step by step through the entire divorce process in the United States. We will demystify the jargon, expose the common pitfalls, and give you the knowledge to move forward with clarity and confidence. This isn't about legal advice. This is about empowerment. It's about turning you from a passive passenger in a terrifying process into an informed, active participant who can make the best decisions for your future. We are going to transform your fear and uncertainty into a clear, actionable plan. So, where does this journey begin? It doesn't start with filing a paper. It doesn't start with hiring a lawyer. It starts with one fundamental question: why? Not the personal why, but the legal why. This is what the courts call the grounds for divorce. This is the legal reason you are stating to the court for ending the marriage. And this first decision, choosing your grounds, can set the entire tone and trajectory of your divorce. Broadly speaking, every state in the U.S. offers a form of no-fault divorce. This is by far the most common path people take. The term itself is simple. You're not required to prove that your spouse did anything wrong to cause the marriage to end. You don't need to air your dirty laundry in a courtroom. Instead, you simply state that the marriage is over due to reasons like irreconcilable differences or an irretrievable breakdown of the marriage. Think of it as telling the court, "Look, we just can't make it work anymore, and there's no reasonable chance of getting back together." This no-fault approach was a revolutionary change in family law. It was designed to reduce the conflict, the shame, and the adversarial nature of divorce. It acknowledges that sometimes marriages just end, without one person needing to be the bad guy. For most people, this is the right choice. It's generally faster, cheaper, and emotionally less taxing. It allows you and your spouse to focus on the practical issues, dividing assets, creating a parenting plan, rather than engaging in a painful and often pointless blame game. If you and your spouse are relatively amicable and agree that the marriage is over, a no-fault divorce is almost certainly your starting point. But it's not the only option. There's another category, known as a fault-based divorce. While every state has a no-fault option, many states still allow you to file for divorce based on the specific misconduct of your spouse. These fault grounds are like a list of serious offenses against the marriage contract. The exact list varies from state to state, but the common ones include adultery, abandonment or desertion for a certain period of time, cruelty, which can be physical or extreme emotional abuse, habitual drunkenness or drug addiction, and conviction of a felony. So why on earth would anyone choose this path? If no fault is easier and less contentious, why would you intentionally start a war by accusing your spouse of something terrible in a legal filing? The answer, in the states that still give it weight, comes down to two things: money and time. Let's talk about money first. In some states, proving that your spouse's misconduct, their fault, is what destroyed the marriage can directly impact financial outcomes. A judge might award a larger share of the marital property to the innocent spouse. It can be a significant factor in determining the amount and duration of alimony, also known as spousal support. For example, if one spouse spent a substantial amount of marital funds on an affair, a judge might compensate the other spouse for that financial loss during the property division. Proving fault can give you leverage. It changes the narrative from "we both decided to split" to "my spouse's actions forced this outcome, and I have suffered damages as a result." The second reason is time. In many states, to file for a no-fault divorce, you are required to be physically separated from your spouse for a specific period. It could be 6 months, a year, or even longer. This is called a mandatory separation period. But if you can prove fault, like adultery or cruelty, some states allow you to bypass this waiting period and file for divorce immediately. For someone in an abusive situation or who simply needs to move on with their life and finances, this can be a powerful incentive to pursue a fault-based divorce. However, you must understand the massive trade-off. Choosing to file on fault grounds is like pouring gasoline on a fire. You are making a public legal accusation. You are no longer just ending a partnership, you are trying to prove a case. This means you need evidence. Hard evidence. For adultery, this could mean photos, emails, text messages, or the testimony of a private investigator. For cruelty, it could mean police reports, medical records, or witness testimony. Gathering this evidence is invasive, expensive, and incredibly stressful. Furthermore, it guarantees a fight. Your spouse isn't going to just accept the accusation. They will fight back, deny the claims, and possibly make counter-accusations against you. This immediately escalates the conflict, drives up legal fees exponentially, and can inflict deep, lasting emotional wounds, especially if children are involved. The short-term leverage you might gain could be completely wiped out by the long-term financial and emotional cost of the battle. So, this is your very first strategic decision. Do you take the common, less combative path of a no-fault divorce, focusing on a practical resolution? Or do you have a compelling, provable reason to file on fault grounds, understanding that it will likely ignite a more intense and costly legal battle, but could potentially lead to a more favorable outcome or a faster timeline? This isn't a decision to be made lightly. It's a conversation you must have with a qualified attorney who understands the specific laws and judicial tendencies in your state. In some states, proving fault has almost no impact on the financial outcome, making it a pointless and destructive exercise. In others, it can be a game changer. Understanding this distinction right here at the beginning is the first step to taking control of the process. It's the first landmark on your map, guiding you away from that first potential landmine and onto a clearer, more deliberate path. So let's walk that path. The first thing you're likely to encounter isn't a legal form or a judge. It's a thick, disorienting fog. The fog of the unknown. It's a whirlwind of questions with no apparent answers. Where do I even start? What papers do I file? Do I need a reason? Does it matter who files first? This fog is paralyzing. It's a mix of legal jargon, advice from well-meaning friends, and terrifying stories you've seen on TV. It makes you feel small and powerless, like you're lost in a forest at night with no compass. Our mission right now is to build that compass. We're going to cut through that fog with the first, most fundamental concept in any divorce: jurisdiction. It sounds like a boring legal term, but I promise you, it's the most important question you will answer first. Jurisdiction simply means, which court has the power to hear your case? You can't just file for divorce anywhere. You can't file in the state where you got married 10 years ago if you don't live there anymore. You can't file in a state known for quickie divorces, unless you actually live there. The power to grant you a divorce belongs to the state where you or your spouse reside. And every state has a residency requirement. This is a specific amount of time you must have lived in that state, and sometimes even a specific county before its courts will even look at your paperwork. This period varies, but it's typically anywhere from 6 months to a year. So the first piece of actionable information you need to find is the residency requirement for your state. This is your "you are here" marker on the map. It establishes the legal ground on which your entire case will be built. If you file in the wrong place, the case gets thrown out, and you've wasted time, money, and emotional energy. So before you do anything else, you must determine where you have the legal right to file. Once you've found your courthouse, the next clearing in the fog is understanding the why. These are the grounds for divorce. For decades, in movies and books, this was the central drama. Someone had to have done something wrong. There had to be a villain and a victim. This is what's known as a fault divorce. And while it still exists, the entire landscape has been transformed by a much more common and far less confrontational concept: the no-fault divorce. Every single state in the US now offers some form of no-fault divorce. This is a monumental shift. It means you do not have to prove that your spouse did something terrible to get a divorce. You don't need to hire a private investigator or present scandalous evidence in court. The grounds for a no-fault divorce are usually stated as irreconcilable differences or an irretrievable breakdown of the marriage. Let's translate that. It's the law's way of saying, this marriage is broken, and there is no reasonable chance of fixing it. That's it. It's a quiet, dignified acknowledgement of a sad reality. No blame is legally assigned. It allows two people to end their marriage without having to tear each other apart on the witness stand, which is especially critical when children are involved. For the vast majority of people watching this, the no-fault path will be the one you take. It is the modern standard. So why do fault grounds still exist? In some states, filing on fault grounds like adultery, cruelty, abandonment, or imprisonment can potentially impact the outcome, particularly when it comes to alimony or the division of assets. The theory is that if one person's bad behavior financially damaged the marriage, the court might compensate the other spouse for that. However, pursuing a fault-based divorce is a major strategic decision that you must discuss with an attorney. It is almost always more expensive, more time-consuming, and infinitely more stressful. It turns the divorce process into a battle, forcing you to prove your spouse's wrongdoing in a public forum. It's a scorched earth tactic that can inflict deep, lasting wounds on a family. While it might seem tempting in a moment of anger, you have to ask if the potential financial gain is worth the emotional cost. Okay, you've figured out where you can file, jurisdiction, and why you can file, grounds. Now we arrive at the first tangible physical step, the petition. The official name varies by state. It could be a petition for dissolution of marriage, a complaint for divorce, or something similar. But its purpose is the same. This is the document that officially starts the divorce process. Filing it with the court is like turning the key in the ignition. And this is where a lot of fear and anxiety kicks in. The word petition sounds aggressive. It feels like you're suing your spouse. And while technically that's true, it's helpful to reframe it. This document is a formal request to the court to legally end your marriage and to help you and your spouse untangle your shared lives. So what's actually in this scary-sounding document? It's mostly just information. It will state basic facts. Your names, your addresses, when and where you were married. It will list the names and birth dates of your children. It will state that you meet the state's residency requirement. And it will declare the legal grounds for the divorce, most likely those irreconcilable differences. Then comes the part that causes the most stress, the prayer for relief. This is a section where you have to state what you are asking the court to grant you. This is your initial wish list. You'll have to check boxes or write in what you want regarding child custody, child support, alimony, and how you want property and debts to be divided. This feels incredibly high stakes, as if you're carving your demands into stone. But here's the secret. For the most part, you're not. In many states, this initial request is a starting point for negotiation. You often have to ask for everything you might possibly want because it can be difficult to add things in later. It is a strategic opening move, not a final demand. It's you telling the court, here is what I believe is a fair and just outcome. Your spouse will get their chance to respond with what they believe is fair. The final result will likely land somewhere in the middle, hammered out through negotiation, mediation, or a judge's decision. The person who files this petition is called the petitioner. The other spouse, who will receive the papers, is the respondent. Does it matter who files first? Legally, not really. The petitioner files the initial paperwork and speaks first in court, but it doesn't give them a significant legal advantage in the outcome. The decision to file first is more about taking control of the timing and starting the process on your own terms, rather than waiting to be reacted to. Once the petition is filed with the court clerk and the filing fee is paid, the divorce case officially exists. It has a case number. It is real, but it's only halfway there. The most dreaded, most dramatized moment in any divorce is next: serving the papers. Your spouse has to be officially notified that you have filed for divorce. This isn't just a courtesy. It's a cornerstone of the American legal system called due process. You can't have a legal proceeding against someone in secret. They have a constitutional right to be notified and to have an opportunity to respond. This notification process is called service of process. And yes, it can be as dramatic as you see in the movies. A sheriff's deputy or a private process server can show up at your spouse's home or workplace and hand them the papers. For someone who is not expecting it, this can be a shocking and deeply upsetting experience. But it doesn't have to be that way. If the separation is more amicable, there are gentler options. Your spouse can agree to sign an acceptance of service or a waiver of service form, acknowledging they've received the documents without the need for a stranger to show up at their door. This is the first opportunity in the legal process for you and your spouse to choose cooperation over conflict. Regardless of how it happens, the moment the respondent is served, a clock starts ticking. They now have a limited amount of time, usually 20 to 30 days, to file a formal response with the court. And that is the critical turning point. You, the petitioner, have made your opening statement. You've navigated the fog of jurisdiction and grounds. You've filed the petition and laid out your initial requests. You have set the process in motion. Now the ball is in your spouse's court. Their response will set the tone for everything that follows. It will determine whether the path ahead is one of collaborative problem-solving or a contentious uphill battle. What they do next and how you react to it is the subject of our next chapter. So the petition has been served. The ball is now in your spouse's court. This moment is a critical fork in the road, and the path they choose will fundamentally shape the entire landscape of your divorce. There are essentially 3 directions this can go, and each one leads to a vastly different journey. The first, and by far the smoothest path, is the uncontested response. This is the dream scenario for anyone hoping for an amicable split. An uncontested response means your spouse agrees with everything you've laid out in the petition. They agree to the divorce itself, and more importantly, they agree on all the major terms: how to divide the property and debts, the custody arrangement for the children, the amount of child support, and whether or not there will be spousal support, also known as alimony. When this happens, they typically sign a waiver or a simple agreement, and the divorce proceeds almost like an administrative process. You and your spouse, often with the help of attorneys or a mediator, will draft what's called a marital settlement agreement. Think of this as the master rulebook for your post-divorce lives. It's a legally binding contract that details every single decision. Once it's signed by both of you and approved by a judge, it becomes part of your final divorce decree. An uncontested divorce is faster, dramatically cheaper, and infinitely less stressful. It signals that both of you have chosen to be co-pilots landing a plane, rather than adversaries in a dogfight. But let's be realistic. That's not how it goes for most people. The deep emotional wounds and legitimate disagreements that led to the divorce in the first place don't just vanish when a legal document appears. This brings us to the second and far more common path: the contested response. In this scenario, your spouse formally files a legal document called an answer. The answer is their official reply to your petition, and it's where they go through your claims, point by point, and state whether they admit or deny them. They might admit that the marriage is broken but deny that you should have sole custody of the children. They might admit that you own a house together but deny your proposed 50-50 split of its value. Often, along with the answer, they will file their own set of demands in a document called a counterpetition or cross-complaint. This is where they don't just react to your requests, they make their own. They are no longer just the defendant, they become a plaintiff in their own right. They might ask for primary custody, request spousal support from you, or claim that a specific asset you thought was yours is actually marital property. This is the moment the legal battle truly begins. The filing of a contested answer and counterpetition is like the other side pushing their own stack of chips into the middle of the table. It's a clear signal. I don't agree with your terms and I'm prepared to fight for mine. The tone is no longer collaborative, it's adversarial. The process will now involve negotiation, legal maneuvering, and potentially a trial. It will take longer, cost more, and be significantly more emotionally taxing. Then there's the third path, the path of inaction. What happens if your spouse, upon being served with divorce papers, does nothing? They don't respond, they don't hire an attorney, they just ignore it, hoping it will go away. This is one of the most dangerous and misunderstood aspects of the process. In the legal world, silence is not golden. It's considered consent. If the legally mandated time frame to respond passes, usually 20 to 30 days depending on the state, you, the petitioner, can file a motion for a default judgment. A default is essentially a forfeit. Because the other party failed to show up and present their side of the story, the court assumes they don't contest what you've asked for. The judge can then grant your divorce and approve all the terms you requested in your initial petition, without any input from your spouse. Now, it's not always a simple slam dunk. A judge will still review your requests to ensure they aren't completely outrageous or harmful to the children. They won't let you ask for $1 billion from a spouse who makes minimum wage. But within the bounds of reason, you could be granted everything you asked for. The house, the car, the custody schedule you wanted, the support amount you proposed. For the person who failed to respond, a default judgment can be catastrophic. They wake up one day to find their divorce is final, and all the major decisions about their children, their property, and their financial future have been made for them, without them. It is a brutal, self-inflicted legal wound. So whether your spouse agrees, argues, or simply disappears, their response or lack thereof sets the stage. But regardless of which of these three paths you start down, an immediate and pressing question arises. What happens now? The final divorce could be months or even years away. But you're separated today. Who is going to live in the house? Who will the kids stay with this weekend? Who is responsible for paying the mortgage and the car insurance this month? Life doesn't pause to wait for the legal system. This is where the concept of temporary orders comes in. This is arguably one of the most critical, high-stakes phases of the entire divorce process. Temporary orders are court-ordered rules of engagement that govern your lives while the divorce is pending. They are a legal framework designed to create stability and predictability in the chaotic period between separation and the final decree. Think of it as a temporary truce with court-enforced terms. Either you or your spouse can file a motion asking a judge to put these orders in place. This often leads to the first actual court hearing of your case. So what do these orders cover? Everything that's an immediate source of conflict. First, child custody and visitation. The court will establish a temporary parenting schedule. This isn't the final custody arrangement, but it determines who the children live with primarily and what the visitation schedule for the other parent will be during the divorce proceedings. The court's primary concern here is the best interest of the child, and they will often lean towards whatever arrangement causes the least disruption to the children's current routine, a legal principle often referred to as maintaining the status quo. Second, money. The court will issue temporary orders for child support and potentially spousal support. Based on financial affidavits where you both disclose your income and expenses, the court will calculate how much the higher-earning spouse needs to pay to the other to ensure the children are provided for, and that the lower-earning spouse isn't left in financial ruin while the case is ongoing. The court can also order who is responsible for paying which marital bills, the mortgage, the car payments, the health insurance. This prevents one spouse from maliciously cutting off the other financially or trying to ruin their credit by letting joint obligations go into default. Third, property. A temporary order can grant one spouse exclusive use of the marital home. This is a huge point of contention. The judge will have to decide who gets to stay and who has to move out. They can also issue restraining orders preventing either spouse from selling, hiding, or squandering marital assets. You can't just decide to empty the joint savings account or sell off the stocks the day after you get served. These orders lock everything down. The hearing for these temporary orders is often a rude awakening. It's typically the first time you and your spouse will see each other in a formal courtroom setting, standing on opposite sides, with your lawyers arguing over the most intimate details of your life. Feels surreal. You'll present evidence, you might have to testify, and a judge who knows nothing about you other than what's in a few documents will make monumental decisions about your children and your finances that you will have to live with for the foreseeable future. The outcome of this hearing is incredibly important, not just because it dictates your life for the next several months, but because these temporary orders often create a new status quo that can heavily influence the judge's final decision. Once these temporary rules of engagement are set, the case moves into its next major phase. The initial shock is over, the immediate fires have been put out, and the battle lines have been drawn. Now the real work begins. Both sides need information. They need documents, they need answers, they need to know exactly what assets exist, how much debt there is, and what the other side plans to argue. This is no longer about just making claims. It's about proving them. And to do that, both sides are about to be given a legal arsenal of tools designed to uncover the truth, to open financial records, and to compel the other person to answer questions they would never answer willingly. This next stage of the war is all about information, and it's called discovery. Discovery is where the gloves come off. It's the part of the divorce that feels less like a legal process and more like an espionage thriller. Imagine you and your spouse are two opposing nations. For months or even years you've been operating with limited intelligence. You only know what they've chosen to tell you. You see the public-facing budget, the joint checking account, the mortgage statement, but you have no idea what's happening in their covert operations, their secret slush funds, their hidden alliances. Discovery is the legal equivalent of sending in the spy satellites, hacking the mainframe, and interrogating the high-level operatives. It is the systematic, court-sanctioned process of forcing the other side to show you their hand. All of it. Why is this so brutally important? Because a fair settlement is impossible without a full and honest accounting of the facts. People lie. Not just about infidelity but about money. They downplay their income. They forget about a retirement account they started at an old job. They claim a business is failing right before they file for divorce, only to have it miraculously recover the month after it's finalized. I saw a case where a husband, a self-employed contractor, claimed he was barely making ends meet, earning just $40,000 a year. His lifestyle, however, told a different story. Through discovery, his wife's attorney didn't just ask for his tax returns. They subpoenaed the bank records for his failing business. And what did they find? Hundreds of thousands of dollars in cash deposits that never made it onto the books. He was living a completely different financial life in secret. Without discovery, his wife would have walked away with a fraction of what she was owed, potentially facing financial ruin, all based on a lie. This process is your lie detector. It's your truth serum. So, how do you get this information? Your attorney has a set of powerful, specialized tools. The first is called interrogatories. Think of this as the most intense, legally binding game of 20 questions you will ever play. They are a written list of questions that your spouse is required to answer, in writing under oath. And these aren't casual questions. They are surgically precise. List every employer you have had for the past 10 years, including dates of employment and final salary. Identify every bank account, investment account, or retirement account that you have had an interest in, either jointly or individually, for the past 7 years. State the date you believe the marriage irretrievably broke down, and provide a factual basis for that belief. Answering these is a nightmare. It's tedious, invasive, and forces them to put their story down on paper, locking them into a version of events. If they lie, they've just committed perjury. The next tool is the request for production of documents. This is the show me the receipts phase of the divorce. It's where your lawyer says, "It's great that you answered our questions. Now prove it." This is a formal demand for physical or digital copies of documents, and the list can be staggering. We're talking years of bank statements for every single account, credit card statements, pay stubs, tax returns both personal and business, deeds to property, vehicle titles, loan applications, retirement account statements, life insurance policies. It is a paper avalanche designed to bury you. But within that avalanche is the evidence. It's in these documents that you find the truth. You find the credit card charges for a hotel you've never been to. You see the Venmo transfers to a name you don't recognize. You discover the existence of a brokerage account you never knew about. The numbers don't lie. A single bank statement can unravel an entire web of deceit. Then there are requests for admission. These are a bit different and incredibly strategic. Instead of asking a question, your lawyer makes a statement, and your spouse is required to either admit or deny it. For example, admit that on May 15th, you withdrew $50,000 from the joint savings account. Or, admit that you are the sole owner of the property located at 123 Main Street. They can't waffle or explain. They have to say admitted or denied. If they admit it, that fact is now considered legally settled for the rest of the case. It doesn't need to be proven in court. It's a way of narrowing down the issues and forcing the other side to go on record, locking them into a position they can't later escape. It's a legal trap, and it's incredibly effective. Finally, we have the main event. The one you've seen in movies, the deposition. This is the single most intimidating and crucial part of the discovery process. A deposition is a formal, out-of-court testimony given under oath. You, your lawyer, your spouse, and their lawyer will gather in a conference room. A court reporter will be there, typing down every single word that is said, creating an official transcript. There is no judge. It's just you and the opposing attorney face to face. For hours, they will grill you. They will ask you about your finances, your job, your kids, your personal life, the affair you had, the affair you suspect they had. Every detail of your life is fair game. Their goal is twofold. First, they want to find out what you know and what your story is. They want to hear it from your own mouth on the record. Second, and more importantly, they want to see how you hold up under pressure. Are you credible? Do you get angry easily? Do you break down and cry? Do you contradict yourself? They are testing you, sizing you up as a witness to see how you would perform in front of a judge. A bad deposition can destroy a case. If you come across as a liar or as unstable, the other lawyer will know they have the upper hand. The key to surviving a deposition is preparation with your own attorney. The rules are simple but hard to follow under stress. Listen to the entire question before you answer. If you don't understand it, ask for clarification. Answer only the question that was asked and nothing more. Do not volunteer information. Be truthful. If you don't know the answer, the correct response is, "I don't know." If you don't remember, the correct response is, "I don't recall." It is a grueling, emotionally draining marathon of mental chess. This entire discovery process can take months, sometimes over a year. It's expensive, it's exhausting, and it feels like a profound violation of your privacy because it is. You will be forced to turn over your most personal financial documents. You will be asked uncomfortable questions about the most intimate details of your life. It feels like your entire existence is being put under a microscope for a hostile audience. But it is the only way to level the playing field. It is the only way to ensure that the final division of your life together is based on fact, not fiction. All this data, all these documents, all this testimony, it becomes the raw material your attorney will use to build your case. It provides the leverage for a fair settlement, or the ammunition needed to win at trial. Now that the intelligence has been gathered, the next step is to figure out what it's all worth and how to start fighting for your share. This process is called valuation, and it's where the abstract numbers on a page are transformed into the concrete reality of your financial future. It's not just about slapping a price tag on the house, or looking up the Kelley Blue Book value of your car. This is a meticulous, often complex, and absolutely critical phase that determines the size of the financial pie you and your spouse will be dividing. Get this wrong and you could leave tens or even hundreds of thousands of dollars on the table without ever knowing it. Before we can value anything, we have to understand the two most important words in property division: marital and separate. Everything you and your spouse own falls into one of these two buckets, and the distinction is the bedrock of your entire financial settlement. Marital property is, generally speaking, anything and everything acquired or earned by either of you from the date of marriage to the date of separation. It doesn't matter whose name is on the title. It doesn't matter whose paycheck bought it. If you earned it during the marriage, it's typically considered ours. Think of it like a shared pot. Your salary went into the pot. Your spouse's salary went into the pot. The house you bought with money from the pot is a pot asset. The 401k contributions made during the marriage, they went into the pot. The credit card debt you racked up buying groceries and paying for family vacations, that's a pot liability. The law in most states views marriage as an economic partnership, and the marital estate is the total value of that partnership. Separate property, on the other hand, is what belongs to you and you alone. This typically includes three categories. First, anything you owned before you got married. That classic car you had in college, the savings account you started with your first job, those are presumptively yours. Second, inheritances. If your grandmother left you her diamond ring or a sum of money specifically in your name, that is your separate property, even if you received it during the marriage. Third, gifts given specifically to you and not to the couple from a third party. For example, if your parents gave you $10,000 for a down payment on a house titled in both your names, that money likely became marital property. But if they gave you a check for $5,000 for your birthday and said, "This is just for you," that's likely your separate property. Now here's where it gets messy. Separate property can lose its separateness through a process called commingling or transmuting. Imagine you had a $50,000 savings account before you got married. That's your separate property. But after the wedding, you move that money into a new joint savings account, and then both of you start depositing your paychecks into it and paying bills from it. You have now commingled your separate funds with marital funds, and it can be incredibly difficult, if not impossible, to trace and pull your original $50,000 back out. You've effectively turned it into a marital asset. The same goes for the house you owned before the marriage. If you add your spouse to the deed, or you use marital funds like your joint paychecks to pay the mortgage and make improvements for years, a portion or even all of the equity in that house could be considered marital. This is why the financial discovery we talked about is so crucial. Tracing the origin of assets is a forensic exercise, and the burden of proof is on the person claiming an asset is separate. So, with that framework in mind, how do you actually value the marital pot? We go asset by asset, liability by liability, and create a master balance sheet. Let's start with the biggest one for most people, the house. You can't just go on Zillow and use their Zestimate. That's a starting point, a conversation starter, but it won't hold up in court. You generally have two options. A comparative market analysis, or CMA, from a real estate agent is a good low-cost way to get a solid idea of the value. But the gold standard, and what a judge will almost always require if you can't agree, is a full appraisal from a licensed real estate appraiser. They will conduct a detailed inspection and provide a legally defensible report on the home's fair market value as of a specific date. This is the number you'll use for your balance sheet. Next are the financial accounts. This is the easy part. For checking, savings, and brokerage accounts, the value is the statement balance on the date of separation. For retirement accounts like a 401k or an IRA, it's a bit more nuanced. You need the statement from the date of marriage and the statement from the date of separation. The value to be divided is the growth that occurred during the marriage, not the total balance. If you had $100,000 in your 401k the day you got married, that premarital portion is your separate property. The millions that it grew into during your 30-year marriage? That growth is marital property. Now for the really complex assets, a business. If you or your spouse own a business, you cannot simply guess its value. This is expert territory. You will likely need to hire a forensic accountant or a certified business valuator. They use several methods to determine a company's worth. They might look at its assets and liabilities, its cash flow, or compare it to the sale price of similar businesses. They also have to value something called goodwill, which is the intangible value of the business's reputation and customer base. Business valuation is one of the most contentious and expensive parts of any divorce, but if a business is the main marital asset, getting an accurate, independent valuation is non-negotiable. Then there's all the other stuff, personal property, cars, boats, furniture, art, jewelry, electronics. For vehicles, you can generally agree to use a source like Kelley Blue Book. For household furniture, unless you have priceless antiques, it's often not worth fighting over. Courts hate dealing with who gets the toaster. The best approach is to create a list and divide it yourselves. If you can't, you might have to assign garage sale values to everything and then take turns picking items. For high-value items like fine art, expensive jewelry, or collectibles, you'll need a formal appraisal from a specialist in that field. Of course, we can't forget the other side of the balance sheet: the debts. Marital debts are divided just like marital assets. This includes the mortgage on the house, car loans, and credit card balances. The key is determining if the debt was incurred for a marital purpose. The $20,000 in credit card debt from buying furniture, paying for kids' activities, and going on family vacations is clearly marital. But what about the $5,000 your spouse charged at a casino right after you separated? Or the $10,000 loan they took from their brother without telling you? Those are likely to be considered their separate debts. Student loans are a particularly thorny issue, and the law varies by state. In some states, if a spouse took out loans to get a degree that ultimately benefited the marriage, for example, by increasing their earning capacity which then supported the family, the loan may be considered a marital debt, even if it's only in one person's name. Once you've gone through this entire process, you have your master document, the marital balance sheet. It's a simple spreadsheet. On one side, you list every single marital asset and its agreed upon or appraised value. On the other side, you list every marital debt and its balance. You subtract the total debts from the total assets, and what you're left with is the net marital estate. This is the number. This is the total value of the economic partnership you built. This figure is the foundation for every negotiation that comes next. Having this clear black and white picture of your financial world is incredibly empowering. The ambiguity is gone. The guesswork is eliminated. You are no longer fighting over vague ideas of what's fair. You are now dealing with a concrete number. You know the exact size of the pie. Now, and only now, can you begin the strategic and often emotional process of deciding how to slice it up. This process is governed by one of two major legal systems in the United States, and which one you live under will fundamentally change the entire negotiation. It all comes down to whether you live in a community property state or an equitable distribution state. First, let's talk about the community property states. There are 9 of them: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. In these states, the law generally views the marriage as a partnership. Everything earned or acquired by either spouse during the marriage is considered community property and belongs to both partners equally. It doesn't matter if your name is on the paycheck or if his name is on the car title. If it came into the marriage after the wedding day and before the date of separation, it's considered part of the community pot. The starting point for dividing this pot is a clean 50-50 split. Now, this doesn't mean you take a chainsaw to the house. It means the net value of the community estate is split down the middle. One spouse might get the house, but they'll have to give up other assets, like a larger share of a retirement account, to make the final tally equal. It's a straightforward mathematical approach, at least in theory. But the vast majority of states, the other 41, are equitable distribution states. And this is where things get much more subjective, much more complex, and often much more contentious. The key word here is equitable. Equitable does not mean equal. It means fair. And what a judge considers fair is based on a whole host of factors that go far beyond a simple calculator. So what are these factors? What does a court look at when deciding how to slice the pie in a way it deems just? The list is long and it can be different from state to state, but there are common themes. First, the length of the marriage. A 2-year marriage where both spouses came in with their own careers and assets is going to be treated very differently from a 25-year marriage where one spouse stayed home to raise the children. The longer the marriage, the more intertwined your financial lives become, and the more likely a judge is to aim for a division that leaves both parties on similar financial footing. Next, the age and health of each spouse. A healthy 35-year-old with a long career ahead has a much greater ability to recover financially than a 60-year-old spouse with a chronic illness who may be unable to work. The court will consider this future reality when dividing the assets you have today. Of course, the court looks at the income, property, and earning capacity of each person. If one spouse is a surgeon earning $500,000 a year, and the other is a part-time teacher's aide, a 50-50 split might not be equitable. The court will look at your education, your work history, and your potential to earn money in the future. And this leads to one of the most critical factors, one that is so often a source of fear and anxiety: the contribution of each spouse to the marriage, including contributions as a homemaker. Let me be crystal clear about this. The law in every state recognizes that raising children, managing a household, and supporting your spouse's career is a valuable economic contribution. It is not less than the contribution of the spouse who earned the paycheck. That work enabled the other spouse to advance their career. The courts will weigh those non-financial contributions when dividing the assets, ensuring the stay-at-home parent isn't unfairly punished for sacrificing their own career for the benefit of the family. The court also looks at the standard of living established during the marriage. They will try as much as possible to ensure that neither spouse experiences a drastic and unfair drop in their quality of life, especially after a long marriage. And here's a factor that always gets a lot of attention: marital misconduct. But not in the way you might think. Most states are no fault for the divorce itself, meaning you don't have to prove someone cheated to get divorced. However, when it comes to dividing property, financial misconduct absolutely matters. If one spouse gambled away the family savings or spent tens of thousands of dollars on an affair, a judge can view that as dissipation or waste of marital assets. They might give the other spouse a larger share of the remaining pie to compensate them for that loss. It's not about punishing the affair. It's about making the innocent spouse financially whole. To make any of this work, you have to understand the fundamental difference between marital property and separate property. Marital property is the pie you're dividing. It's the house you bought together, the cars, the furniture, the bank accounts, the retirement funds that grew during the marriage. It's almost everything you acquired from the day you said, "I do," until the day you separated. Separate property is what's yours alone. This typically includes 3 things: anything you owned before the marriage, any inheritance you personally received during the marriage, and any gift given specifically to you, and not to you as a couple during the marriage. But here is a $1 million warning. Separate property can lose its separate status if you're not careful. This is called commingling, or mixing assets. Let's say you inherited $50,000 from your grandmother. That's your separate property. But then you deposit that money into your joint checking account, and you use it to pay bills and go on vacations for a few years. You have now commingled that money, and it has almost certainly become marital property, part of the pie to be divided. Or maybe you used that inheritance as a down payment on the marital home. That home is now a marital asset, and your separate $50,000 contribution is likely blended into the overall equity of the house, making it very difficult to pull back out. Keeping separate property truly separate requires meticulous record-keeping and a clear intention to not share it with the marital enterprise. So let's talk about the big-ticket items. How are they actually divided? The marital home is usually the largest and most emotionally charged asset. There are typically 3 options. 1. You sell the house and split the proceeds. This is the cleanest break. 2. One spouse buys out the other. For example, if there's $200,000 in equity, one spouse might refinance the mortgage and pay the other their $100,000 share. This often depends on whether one spouse can actually afford to maintain the home on their own. 3, and this is less common, the spouses continue to co-own the house for a period, usually so the children can stay in the home until they're older, at which point the house is sold. Then there are retirement accounts, 401ks, pensions, IRAs. This is often the second largest asset, and it is absolutely marital property for the portion that grew during the marriage. You do not just cash these out. Doing so would trigger massive taxes and penalties. Instead, the division is handled through a special court order called a Qualified Domestic Relations Order, or a QDRO. This order is sent to the plan administrator, and it tells them to create a separate account for the non-employee spouse with their share of the funds. It is a tax-free transfer. This is a complex legal document, and getting it wrong can have devastating financial consequences years down the line. And finally, we have to talk about the other side of the balance sheet: debt. Mortgages, car loans, student loans taken out during the marriage, and especially credit card debt, are all part of the marital estate. Just like assets, marital debts have to be divided. The court will look at who incurred the debt and for what purpose, but generally, debt acquired for a family purpose is a family debt. It is a rude awakening for many to realize that they are not just dividing up the good stuff, they are also being assigned a share of the financial obligations, regardless of whose name is on the credit card. Dividing the marital estate is a painstaking process of unwinding a shared financial life. It's an attempt by the legal system to take years of combined effort, sacrifice, and growth and translate it into a final balance sheet that is, in the eyes of the law, fair. But dividing the property you have now is only half the financial story. What about the income you'll need to live on tomorrow? What happens when one spouse earns significantly more than the other, or when children are involved? That's where the two most contentious topics in all of divorce law come into play: alimony and child support. And the rules governing them might shock you. Let's start with alimony, also known as spousal support or maintenance. This is one of the most misunderstood and emotionally charged aspects of a divorce. The very idea can feel deeply unfair, whether you're the one paying or the one receiving. So let's cut through the noise. The core purpose of alimony is not to punish the higher-earning spouse or to reward the lower-earning one. It's an attempt by the court to mitigate the unfair economic effects of a divorce. The law recognizes that when two people build a life together, they often make joint decisions that benefit the family unit, but disadvantage one spouse's individual career. Think about the spouse who stayed home to raise the children, sacrificing years of career growth, promotions, and retirement savings so the other could climb the corporate ladder. Or the spouse who relocated across the country for their partner's job, leaving behind their own professional network. When that marriage ends, one person walks away with a high-powered career and a six-figure salary, while the other is left with a decade-long gap in their resume. Alimony is the legal system's tool to try and balance that scale. It's a bridge to help the lower-earning spouse get back on their feet and become self-sufficient. Now, not everyone gets alimony. In fact, it's awarded in a surprisingly small percentage of divorces, typically reserved for marriages of a significant length where there's a large disparity in income. And it's not a one-size-fits-all deal. There are several different types. The most common is rehabilitative alimony. This is temporary support, paid for a set period, designed to give the receiving spouse time to get the education or job training needed to re-enter the workforce and support themselves. For example, a court might award alimony for 3 years to allow a former stay-at-home parent to finish a nursing degree. Then there's permanent alimony, which is increasingly rare. This is usually reserved for very long-term marriages, think 20-25 years or more, where one spouse is of an advanced age or has a disability that prevents them from ever becoming self-supporting. There's also reimbursement alimony, for cases where one spouse financially supported the other through a long, expensive degree, like medical or law school, with the expectation of sharing in the future high earnings, only for the marriage to end shortly after graduation. So how do judges decide who gets alimony for how long and how much? This is where it gets tricky because unlike child support, there's often no rigid mathematical formula. It's highly subjective and varies wildly from state to state, and even from judge to judge. But they all look at a similar set of factors. The single biggest factor is the length of the marriage. A 5-year marriage is far less likely to result in an alimony award than a 25-year marriage. They look at the standard of living enjoyed during the marriage. They analyze each person's age and physical and emotional health. And critically, they assess the financial situation of both parties, their current income, their assets, and their future earning capacity. The court will ask, what does the requesting spouse need to meet their basic expenses? And what can the other spouse reasonably afford to pay after meeting their own needs? They will also look at the contributions each spouse made to the marriage, and this includes non-monetary contributions. Being a homemaker, a primary caregiver, or supporting your spouse's career are all considered valuable contributions that the court will weigh heavily. In some states, a judge can even consider marital misconduct. If one spouse's affair, for example, directly led to the squandering of marital assets, it could influence the alimony decision. It's a complex human calculation, an attempt to find a fair path forward after a shared life has been fractured. But if alimony is the subjective, gray area of divorce finance, child support is the black and white. While it can be just as contentious, the process for determining it is far more structured and predictable. And that's because of one fundamental principle that governs every decision. Child support is the right of the child, not the parent. It is not a payment to your ex. It is your legal and moral obligation to financially support your child, and you cannot waive it, trade it for custody, or refuse to pay it out of anger at the other parent. The money is for the child's benefit, period. Because of this, every state has developed specific guidelines and formulas to calculate the amount of child support. This removes much of the guesswork and ensures that children receive a consistent level of support, regardless of which judge hears the case. While the exact formulas differ, most states use one of three basic models. The most common is the income shares model. The logic here is to approximate what the parents would have spent on the child if the family had remained intact. The court combines both parents' gross monthly incomes to get a total family income. It then uses a state-specific chart to determine the basic child support obligation for that income level. Finally, that obligation is divided between the parents in proportion to their respective incomes. Let's use a simple example. Say parent A earns $6,000 a month and parent B earns $4,000 a month. Their combined income is $10,000. The state guidelines might say that a family with a $10,000 monthly income is expected to spend $1,500 a month on one child. Since parent A earns 60% of the total income, their share of the obligation is $900. Parent B, earning 40%, is responsible for $600. If parent B is the primary custodial parent, parent A would pay them $900 a month. The second model is the percentage of income model, which is simpler. It calculates support based on a set percentage of only the non-custodial parent's income. The percentage increases based on the number of children being supported. The third, used in only a handful of states, is the Melson formula, a more complex version of the income shares model that also ensures each parent's own basic needs are met before calculating the child support amount. Now, what does this money actually cover? It's intended for the child's basic necessities: housing, food, and clothing. But it goes far beyond that. It also covers health insurance premiums and out-of-pocket medical expenses, school fees and supplies, and childcare costs, which can be a massive expense. In some cases, it can also be used for extracurricular activities like sports or music lessons, or even college expenses, depending on state law and the specific agreements made by the parents. This base calculation from the formula is just a starting point. The final amount can be adjusted based on several key factors. The biggest one is parenting time. The more overnights a child spends with the non-custodial parent, the more that parent is spending directly on the child's needs, which can lead to a reduction in their formal child support payment. Other major factors include if a child has special needs or extraordinary medical costs, who is paying for the child's health insurance, and whether either parent has other children from a different relationship to support. Once the order is in place, it is legally binding and enforceable. If a parent refuses to pay, the state has powerful tools at its disposal, including wage garnishment, seizing tax refunds, suspending driver's licenses, and in extreme cases, jail time. Life changes and so can support orders. If a parent loses their job, gets a significant promotion, or if the child's needs change, either parent can petition the court to modify the alimony or child support amount to reflect the new reality. So the checks are being written, the assets have been divided, and the financial ties are being sorted out. But all of this pales in comparison to the next, and arguably most important question: who decides where the children sleep at night? Who makes the critical decisions about their health, their religion, and their education? That is the battle for custody, and it's where things get deeply personal. The outcome isn't decided by an accountant's ledger or a mathematical formula. It's decided by a standard that is deceptively simple and incredibly complex: the best interests of the child. And what that really means in the eyes of the court will change everything you think you know about parental rights. So let's pull back the curtain on this phrase: the best interests of the child. It sounds warm and protective, but in a courtroom, it's a legal scalpel. It's not about what you or your spouse think is best. It's not even necessarily about what the child says they want. It's a comprehensive, multi-factor analysis that a judge undertakes to construct a future for your child based on evidence, testimony, and established legal principles. Every state has its own specific list of factors, but they almost all revolve around the same core questions. Think of it as a scorecard, and the judge is the referee. The first and most fundamental factor is the child's physical and emotional well-being. This is the bedrock. The court asks, which parent is better equipped to provide a safe, stable, and nurturing environment? This goes far beyond just having a bigger house or more money. We're talking about who ensures the child gets to their doctor's appointments, who manages their allergies or special needs. If a child has severe asthma, the parent who has consistently administered their medication, knows the triggers, and has a clear action plan for an attack presents a much stronger case for being the primary physical custodian. It's about the nitty-gritty of daily care. Who provides consistent, healthy meals versus who relies on takeout every night? Who helps with homework and encourages reading versus who puts the child in front of a screen for hours? The court builds a detailed picture of the child's daily life, and who is the architect of that stability? Next, the court scrutinizes each parent's capacity to provide for the child. And this is a place where old assumptions can be shattered. This isn't just about financial capacity, that's what child support is for. This is about the capacity to be an engaged, present parent. The court looks at the moral fitness of a parent, their mental and physical health, and how those aspects impact the child. For example, a parent who works 80 hours a week and travels constantly may be the primary breadwinner. But the court might see the other parent, who has a more flexible schedule, as having a greater capacity to meet the child's day-to-day emotional and logistical needs. This is not a punishment for having a demanding career. It's a pragmatic assessment of who is realistically available to parent. The court will also look at a parent's history. Is there a documented history of substance abuse, domestic violence, or untreated mental illness that could endanger the child? A single accusation won't cut it. The court looks for a pattern of behavior supported by evidence like police reports, medical records, or credible witness testimony. Then comes one of the most powerful factors: the established relationship between the child and each parent. The court wants to maintain continuity and stability wherever possible. They will ask, who has been the primary caregiver? This isn't about biology, it's about function. Who is the one the child runs to when they scrape their knee? Who knows the names of their best friends and their teachers? Who arranges playdates and attends parent-teacher conferences? This person is often referred to as the primary psychological parent. In many families, this role has been historically filled by the mother, but courts are increasingly recognizing that fathers can and do fill this role. If a father was a stay-at-home dad or worked from home and was the one taking the kids to all their activities while the mother had a long commute, that history of primary caregiving carries immense weight with the judge. The court's goal is to disrupt the child's life as little as possible, and that often means keeping them with the parent who has been their main anchor. Now, what about the child's own preference? This is one of the most misunderstood aspects of custody. Many people think, my 14-year-old wants to live with me, so it's case closed. Not even close. A child's preference is just one factor among many, and its importance is directly tied to the child's age and maturity. A 5-year-old's desire to live with the parent who lets them eat ice cream for breakfast will be given virtually no weight. A 16-year-old who can articulate a thoughtful, mature reason for their preference, like wanting to stay in their school district or having a stronger emotional bond with one parent, will be listened to much more seriously. But even then, the judge has to dig deeper. Why does the child have this preference? Is it based on genuine needs? Or is it because one parent has a lax attitude, no rules, and buys them expensive gifts? Or worse, is it because one parent has been systematically turning the child against the other parent? A judge is trained to see through manipulation, and if they suspect a child's preference is the result of alienation, it can backfire on the manipulative parent in a catastrophic way. This leads directly to another critical factor: the willingness of each parent to foster a relationship between the child and the other parent. This is the co-parenting test. The court is looking for the parent who can rise above their own anger and hurt for the sake of their child. The parent who says, even though we are divorcing, I recognize that my child needs their father in their life, is demonstrating maturity that the court values highly. Conversely, the parent who blocks phone calls, refuses to be flexible with scheduling, and constantly badmouths the other parent in front of the child is raising a giant red flag. To a judge, this behavior demonstrates that the parent is prioritizing their own conflict over the child's well-being. In the eyes of the court, a good parent is one who facilitates and encourages the child's relationship with the other parent. Deliberately interfering with that relationship is one of the quickest ways to lose credibility in custody. In highly contentious cases, the judge won't make this decision alone. They have tools and experts at their disposal. The most common is a guardian ad litem, or GAL. A GAL is an attorney appointed by the court not to represent either parent, but to represent the child's best interests. They are the court's eyes and ears. The GAL will conduct an independent investigation. They'll interview you, your spouse, your child in an age-appropriate way. And they'll talk to collateral sources like teachers, doctors, therapists, and family friends. They will review documents and may even visit your home. At the end of their investigation, they will write a detailed report and make a recommendation to the judge about custody and parenting time. While a judge doesn't have to follow the GAL's recommendation, it is often incredibly influential. For the most complex and conflicted cases, the court might order a full-blown custody evaluation, sometimes called a forensic evaluation. This is a deep dive conducted by a specially trained psychologist. This process is exhaustive and expensive. It involves hours of interviews with both parents and the children, psychological testing, observation of parent-child interactions, and a review of all relevant documents. The resulting report is a comprehensive psychological profile of the family, and it provides the judge with an expert opinion on the family dynamics and the custody arrangement that would best serve the child's psychological needs. This is the heavy artillery of custody battles, and its outcome can often determine the final shape of your family for years to come. Ultimately, the judge takes all of these factors: the child's needs, the parent's abilities, the existing relationships, the child's preference, the willingness to co-parent, and the reports from any experts, and weighs them to create a parenting plan. This plan will detail legal custody, who makes the major decisions, and physical custody, which is the schedule of when the child is with each parent. It's a painstaking process designed to look past the conflict of the parents and focus solely on the future of the child. Once the court has painted this detailed picture of the child's life and decided on a parenting plan, the next question becomes purely financial. How do you support this new two-household reality? That brings us to the cold, hard math of child support. A system designed to be fair but often feels anything but. Child support is, at its core, a simple concept. A child is legally entitled to financial support from both parents. It's not a payment to your ex. It's not a punishment or a reward. It is a payment for your child. But that simple concept gets thrown into one of the most complex, emotionally charged, and frequently fought-over calculators you will ever encounter. Almost every state in the U.S. uses a specific formula to determine a baseline child support amount. This isn't a judge picking a number out of thin air. It's a mathematical equation, and the two most important variables in that equation are 1, each parent's gross income, and 2, the number of overnights the child spends with each parent. And right there, you can see how the battle over the parenting plan, which we just discussed, suddenly has a dollar sign attached to every single night. The formulas vary, but they generally fall into two categories. Most states use what's called the income shares model. Think of it like this. The court first calculates how much a married couple at your combined income level would typically spend on their child. Let's say the formula spits out a number of $2,000 a month. Then the court looks at what percentage of the combined income each of you earns. If you earn 60% of the total income and your ex earns 40%, you are responsible for 60% of that $2,000 or $1,200. Your ex is responsible for the other 40% or $800. The payment is then adjusted based on the parenting time schedule and other factors like who pays for health insurance and childcare. A smaller number of states use a percentage of income model, which is simpler. It just takes a flat percentage of the non-custodial parent's income, with the percentage changing based on the number of children. The idea is that the custodial parent is already spending their share directly on the child. But no matter which model your state uses, the conflict almost always boils down to one thing: defining income. This is where the financial battlefield gets bloody. What is income? Your base salary, sure. But what about that annual bonus? What about overtime? What about the income from a side business you run on weekends? What if you're a salesperson who lives on commission? All of it is potentially on the table. And this leads to one of the most common and destructive tactics in a contentious divorce: the sudden, mysterious drop in income. The business owner who claims their business is suddenly on the brink of failure. The employee who suddenly stops working overtime right before the divorce is finalized. The contractor who suddenly starts getting paid in cash. Courts are not naive. They have seen this 1,000 times. If a judge believes a parent is voluntarily underemployed or unemployed to avoid paying child support, they can do something called imputing income. This means the court calculates child support based on what that parent should be earning, based on their work history, skills, and the job market in their area. They might look at old tax returns, pay stubs, and even expert testimony to determine a fair income level. So, quitting your six-figure job to work part-time at a coffee shop right before your support hearing is a strategy that will almost certainly backfire, leaving you with a support obligation based on a salary you no longer have. Beyond the base calculation, you have the add-ons. The cost of health insurance premiums for the child is typically split between the parents proportionally to their income. The same goes for work-related childcare costs. Then there are the extraordinary expenses, things like private school tuition, specialized medical treatments, or costs for a child's elite athletic training. These are not automatically included and must be negotiated or argued over. Every expense becomes a potential point of conflict, a line item in the budget of your broken family. And once the child's financial needs are accounted for, the court turns its attention to a topic that is arguably even more volatile: spousal support. You might know it by its more infamous name, alimony. If child support is a formula, alimony is a judgment call. It is one of the most misunderstood aspects of divorce, fueled by old stereotypes of lifelong payments and vindictive ex-spouses. The reality today is very different. Alimony is not automatic. It is not awarded in every divorce. Its purpose isn't to equalize your post-divorce lifestyles forever. Its primary goal is to address a significant economic disparity between the spouses, and to ensure that a lower-earning or non-earning spouse doesn't face financial ruin, especially if they sacrifice their own career for the sake of the marriage or to raise children. Unlike child support, there is rarely a simple calculator. Instead, a judge weighs a long list of factors, and the single most important factor is the duration of the marriage. In most states, a short-term marriage, typically anything under 10 years, sometimes less, is very unlikely to result in a long-term alimony award. A judge might award very short-term temporary support to help a spouse get back on their feet, but that's often it. It's the long-term marriages, those lasting 15, 20, 25 years or more, where alimony becomes a much more significant issue. Another key factor is the standard of living established during the marriage. The court will look at whether one spouse will be unable to maintain a lifestyle that is even remotely comparable to the one they had while married. They will also consider the age and physical and emotional health of each spouse. A 55-year-old spouse who has been out of the workforce for 30 years and has health issues is in a very different position than a 35-year-old who has a recent college degree and a strong work history. This leads to the most crucial factor after the length of the marriage: the earning capacity of each person. The court will scrutinize why one spouse earns less than the other. Did that spouse make a conscious choice to be a stay-at-home parent, thereby enabling the other spouse to climb the corporate ladder? Did they support their partner through medical school or law school with the expectation that they would both share in the future rewards? This is where the concept of fairness really comes into play. The court is trying to untangle years of shared financial decisions and sacrifices. Because of this, there are different types of alimony designed for different situations. The most common form today is called rehabilitative alimony. This is temporary support for a defined period of time. It's designed to give the receiving spouse the resources to get the education or job training they need to re-enter the workforce and become self-sufficient. It's not a pension, it's a launch pad. In some cases, there might be reimbursement alimony, where one spouse is paid back for helping to fund the other's education or career advancement. The type that everyone thinks of, permanent alimony, is becoming increasingly rare. It's typically reserved for very long-term marriages where a spouse, due to age or health, has virtually no chance of ever becoming self-supporting. Even then, many states are moving away from the permanent label, opting for long-term support that still terminates upon the retirement of the paying spouse or the remarriage of the receiving spouse. Both child support and alimony are deeply personal. For the person paying, it can feel like a penalty, a monthly reminder of a failed relationship that drains your ability to move on and build a new life. For the person receiving, it can feel like a lifeline, but also a source of shame or dependence, a number that never quite feels like enough to cover the real costs of raising a child or rebuilding a life from scratch. These numbers, calculated on worksheets and argued over by lawyers, attempt to impose a cold, logical order on the messy, emotional reality of a family breaking apart. They are the financial architecture of your new, separated lives. Once the spreadsheets are closed and the calculators are put away, Once every dollar has been allocated for the children and potentially a spouse, you arrive at the final monumental task: dividing everything else. Every plate, every pension, every point on your credit card. How do you split a life's worth of assets without tearing each other apart? That's the final battle: the division of property. This is where the divorce process becomes a giant, high-stakes accounting project, and your life is the balance sheet. First, you need to understand the fundamental rule of the game your state is playing. There are 2 different rule books in the United States. 9 states are community property states. Think of Arizona, California, Texas, and Washington. In these states, the law views marriage as a 50-50 partnership. Everything acquired during the marriage, from income to assets to debts, is considered owned equally by both spouses. When you divorce, the starting point is a clean, even split. 50% for you, 50% for them. It's like a pizza you order together. You each get half regardless of who paid for it. The other 41 states, the vast majority, are equitable distribution states. And this is where things get much more subjective. Equitable does not mean equal. It means fair. And what a judge considers fair is based on a whole host of factors: the length of the marriage, the age and health of each spouse, each person's income and earning potential, the contributions each person made, including non-financial contributions like being a stay-at-home parent. In an equitable distribution state, the split might be 50-50, but it could just as easily be 60-40 or even 70-30, if the circumstances warrant it. It's less like splitting a pizza and more like a judge deciding who gets which slice, and how big each slice should be, based on who was hungrier and who did the cooking. Before you can divide anything, though, you have to sort everything you own into 2 buckets: marital property and separate property. This is a critical step. Separate property is anything you owned before the marriage, plus things like gifts or inheritances given specifically to you during the marriage. If you owned a classic car before you said, "I do," that car is generally yours to keep. If your grandmother left you her diamond ring in her will, that's yours. Marital property is basically everything else. It's the wealth you built together. The salary you earned, the house you bought, the retirement accounts you funded, the investments you made during the marriage, that's all marital property. It doesn't matter whose name is on the title or the account. If you earned the money and bought a boat while you were married, that boat is likely marital property, even if your spouse never set foot on it. But here's a trap that snares countless people: commingling. This is when you mix separate property with marital property. Let's say you had $50,000 in savings before the wedding. That's your separate property. But after you get married, you deposit that money into a joint checking account that you and your spouse use for bills and groceries. You have now commingled your separate funds. That money has likely lost its separate identity and has transformed into marital property, now subject to division. It's like pouring your personal bottle of water into a community swimming pool. You can't get just your water back out again. Once you've sorted everything into these 2 buckets, the division begins. Let's start with the biggest, most emotional asset for most people: the house. The family home is more than just brick and mortar. It's a repository of memories, stability for the kids, and often the largest financial asset a couple owns. You generally have 3 options. 1. Sell the house and split the proceeds. This is often the cleanest break, turning an emotional asset into cold, hard cash that's easy to divide. 2. One spouse buys out the other. If you want to keep the house, you'll typically need to refinance the mortgage in your name only and pay your ex their share of the equity. 3. Continue to co-own the house. This is rare and complicated, usually only happening for a short period to allow children to finish a school year before a sale. Next up, the silent giant of marital assets: retirement accounts. For 401(k)s, IRAs, pensions. For many couples, this is the second largest asset after their home, and dividing it is a minefield of taxes and penalties if done incorrectly. You can't just write a check from your 401(k) to your spouse. If you do, the IRS will treat it as an early withdrawal, hitting you with a massive tax bill and a 10% penalty. The magic key to unlock these funds correctly is a special court order called a QDRO, which stands for Qualified Domestic Relations Order. A QDRO is a legal document, separate from your divorce decree, that instructs the retirement plan administrator to create 2 separate accounts from the one marital account. It's like a surgical tool that divides the asset cleanly, without triggering any immediate taxes or penalties. Getting the QDRO right is absolutely crucial. A mistake here can cost you tens or even hundreds of thousands of dollars. And then there's the other side of the ledger: debt. Debt is property too, and it gets divided right along with the assets. mortgages, car loans, student loans, and especially credit card debt. In community property states, any debt incurred during the marriage is typically a joint responsibility. In equitable distribution states, a judge will look at who incurred the debt and for what purpose. If your spouse ran up $20,000 on a credit card for lavish personal vacations without your knowledge, a judge might assign that debt solely to them. But be warned, the credit card company doesn't care what your divorce decree says. If your name is on that joint account, they can and will come after you for payment if your ex defaults. This is the financial ghost of your marriage, and the only way to truly exorcise it is to pay off and close all joint accounts as part of the settlement. This whole process relies on one thing: honesty. Both parties are required to provide a full financial disclosure, listing every asset and every debt. But what if one spouse is hiding something? A secret bank account, an undeclared crypto wallet, a side business that only deals in cash. This is where a forensic accountant comes in. They are the financial detectives of the divorce world. They can trace money, uncover hidden assets, and analyze lifestyles to see if the declared income matches the spending habits. If someone claims they make $50,000 a year but they're driving a new Maserati, a forensic accountant will find out where that money is coming from. It's an added expense, but if you have a strong suspicion your spouse is hiding significant assets, it can be the best investment you make in your entire divorce. After all the negotiations, the arguments over who gets the wedding china, and the complex math of splitting pensions, you arrive at the final document, the Marital Settlement Agreement or MSA. This is the peace treaty. It's a comprehensive legal contract that details every aspect of your divorce: custody, support, and the complete division of every single asset and debt. Once you and your spouse sign this agreement, it's submitted to the court and becomes part of your final divorce decree. It is legally binding and extremely difficult to change. Read every single line before you sign it. Have your attorney read it. Understand that you are signing away rights and agreeing to obligations that will affect you for years, if not the rest of your life. With the signed agreement in hand, you attend the final hearing. In many uncontested cases, this is a brief, formal procedure. The judge will review your paperwork, ask a few basic questions to confirm you understand the agreement and are entering into it willingly, and then with the bang of a gavel or the signing of a document, it's over. The judge signs the final decree of divorce. That piece of paper is the finish line you've been crawling, walking, and running towards for months or even years. It legally dissolves your marriage. It makes you two separate, single individuals in the eyes of the law. Holding it can bring a tidal wave of conflicting emotions: relief, sadness, freedom, fear, and maybe even a sliver of hope. The divorce process is a journey through a legal and emotional labyrinth. It starts with the shattering of a shared future and ends with a legal document that allows each of you to build a new one. It tests your patience, your finances, and your very sense of self. But it is a process with an end. And that final decree isn't just an ending. It's a permission slip. It's the legal and emotional clearance you need to close one of the most significant chapters of your life. And finally, turn the page to begin writing the next one. You made it. You survived. And now your future is entirely your own.